Is Austin Bryant? He's where? Mental health? All right, so reset for tomorrow. Matthew Littles? State your name. All right, you were incarcerated. You got 18 different counts. 1, 2, 3, 4 counts of attempted second-degree murder. 1, 2, 3, 4 counts of aggravated assault with a firearm. You have a count, 5 counts of that. Armed burglary of a conveyance, child abuse, shooting into an occupied vehicle, unlawful discharge of a firearm. You got 3 counts of that. Domestic violence battery, 1 count, simple battery, 1 count, and false imprisonment. I realize that some of these are probably contained within each other, but right now there is a no bond. After reviewing the arrest affidavit, the court is going to keep it at no bond until a bond hearing can be held, so that an appropriate amount of bond can be set. Based on the allegations in the arrest affidavit, the court would find, at least at this point, there is no bond or conditions of release that would make it safe for Mr. Littles to be released. But I would suggest the public defender can set a bond hearing in front of a judge as soon as possible to try to see if a judge, after hearing more information, is willing to schedule a bond or set a bond on some or all these charges. All right, so your attorney will come see you. They'll talk to you about getting a bond hearing scheduled. In the meantime, I would assume the state will be determining whether they're going to file, and if so, what they're going to file. All right, thank you.
Judge, I'm sorry, just for clarification, for the record, are you setting a bond on any?
Well, I don't know
of
if
the
there's
18
a
counts?
purpose in setting a bond. I mean, I can. It's just without a bond on a number of the cases, he's not going to be able to bond out, even if I set a bond on the other ones. But I mean, I will if you want me to, or he can just take care of that at the bond hearing when he tries to get bonds scheduled on the ones that would qualify for no bond pending a hearing.
Okay. If the court were to set bonds on any of the counts, is the order staying no bond as to counts 1 through 4?
Well, the court's definitely staying the no bond on 1 through 4. What the court could do, probably 11 through 18, I could set bonds, which, you know, I would be willing to set on 12. I would set 2,500 and would set 150 on the rest. Correct.
It's set for account 12 to 25.
Correct. And then the 1 through 10 is going to remain no bond.
And is that based on the court's dangerousness
Yes.
finding?
The court doesn't believe there's any bond, based on the allegations in the arrest affidavit, the court doesn't believe there's any conditions of release, bond or otherwise, that would make it safe for him to be out. Obviously, that can be proven different in a evidentiary hearing, bond hearing.
I understand, Your Honor. Defense would just object for the record because counts 1 through 9, or really any of the counts, are not punishable by life. felonies, but I understand the court's order.
Okay.
Your Honor, was there no contact order?
No contact with any of the victims, yes. Christopher Valentine. Yeah, if you notice someone getting in the booth, how about give me a heads up, because I don't always look that way. State your name.
Christopher Valentine.
Apparently we are. State your name in the booth.
Brittany Duncan.
And you're here in reference to the case involving Christopher Valentine?
Correct.
Okay. And are you the alleged victim?
Yes, Your Honor.
And what did you want to tell me about anything involving what conditions of release if I set a bond should be?
I just want to ask for a no contact. The violence has escalated and he's broken into my house before. This all happened because he changed the locks on my residence. I'm pregnant as well.
Okay.
I just need to be safe.
All right. Well, count one had a $1,500 bond. Count two had no bond. What the court is going to do is set a bond of $5,000 on count two. No contact with the alleged victim, and that means no messages, no social media contact, no posting of things, no going near where she, she may work or live or shop, and no return to where this happened. Yes.
He does, he has been living at my house. He will be able to come pick up his stuff within.
He would be able to return once, escorted by law enforcement to retrieve any personal items.
Will I be able to be aware of when this is happening?
Yes, law enforcement will make arrangements with you to escort him there. What I would suggest is that you gather his stuff and get it in one location so they don't have to wander through your house looking for his stuff. And just try to make sure you get it all, because I've had situations where they claim there was things missing and so they still wandered through the house looking for those things. So try to be as careful as you can about getting anything you know is his gathered up and in one location. And then law enforcement will escort him there. And if you've got someone else that can be there at that time, then you don't necessarily have to be the person there when law enforcement escorts him there.
Thank
All right? Okay, thank you. Charles Gaston. State your name.
Charles Gaston.
All right, you're here on a domestic violence battery charge. You originally had no bond on that. At this time, the court is going to set a bond of $500, but special conditions of no return to where this occurred, no contact with the victim, and pretrial release is a condition of release. Yes. Yes. And I've read a lot of these. Do you have personal property at this location?
That is correct, sir.
All right, so you can return one time escorted by law enforcement in order to retrieve any personal items. All right, thank you.
Thank you.
No contact, yes. All right, Minerva Gobin. Okay, oh, I see her back. And state your name
Minerva Gobin.
and your name, sir.
Samuel Jarrett?
And are you the alleged victim?
Yes.
And was there something you wanted to say to the court about conditions of release?
This was all just, a huge misunderstanding, and I never wanted any of this to happen. I even told the police officers to drop the charges and everything. This is all a huge misunderstanding, and I just want her to come back home.
Okay. All right. Well, you were here on a charge of domestic violence battery. They have put no bond on that. What the court's willing to do is set a bond of $150. No hostile or unwanted contact with the victim. What that means is you can have contact with him, but if it turns hostile, like you screaming, yelling, or y'all, throwing stuff at each other, that's going to get you put back in jail, probably with no bond. If he says at some point decides he doesn't want to have contact with you, then you can't have contact with him, or he could call the police and that would violate your bond conditions. You understand all that? All right. Thank you. Cheryl Green. State your name.
Cheryl Green.
You were picked up on a domestic violence injunction violation. Originally, it was scheduled for, you had no bond. She does qualify for pretrial release, correct? All right. What the court's going to do is I'm going to allow you to be released on pretrial release, but no contact unless and until the injunction has been lifted. So as long as that injunction's in place, you cannot have contact or it's a violation of your release. All right?
Yes.
Thank you. Mariana Harrison. State your name.
Mariana Harrison.
All right, you're here on a domestic violence battery. You originally had no bond on that. My understanding, she qualifies for pretrial release, correct? All right, court is going to release you on pretrial release. And order no hostile or unwanted contact with the victim.
Yes, sir.
No hostile. All right, thank you. Erica Hornsby, state your name.
Hornsby.
Okay, you are here on a domestic violence battery. You originally had no bond on that. The court is going to set a bond of $5,000 and no contact with the victim. You also were already out on bond on a burglary with assault and criminal mischief charge. The court is revoking the bond on that case. That would be no bond until a judge sets a bond. Thank you. Yes.
What was it?
What were they? Correct.
I thought I didn't have a bond.
Well, according to this, you have Central Florida bonding with a $3,500 bond.
It was supposed to be just a.
No, I did revoke it. I thought she was saying she didn't know she was out on bond.
I was I wasn't supposed to be out on bond. It was actually supposed to be case resolved, and I only had to pay court fines. It wasn't anything to do with bond.
All I know is the paper I have here, if somebody can find something showing that.
Moment, Your Honor.
said,
Unfortunately, Your Honor, I can't find the,
I mean, there's
the
nothing.
related case in case management.
Can you look up the 21 CF?
No, this is for a burglary.
And what's the status of it? Just- Okay.
So, Judge, I see the case is open. The only thing I would note with, I guess, respect to argument for not revoking it is that it's been open since August, and the state has not filed anything one way or the other. So I'm concerned about her being detained in jail without any indication of a filing decision.
Well, obviously, public defender can file a motion to try to get a bond set. I mean, it is a burglary with an assault or battery and criminal mischief, and the new charge is a domestic violence battery. So at this time, the court is going to revoke, and then that'll have to be set. But for right now, just to let you know, Ms. Hornsby, as far as the clerk's computer shows, that case is still open.
well, I thought it was resolved as far as the last time I was here, I came in for open container, and it was resolved with, yeah, but it was actually resolved at
Well-
the time for the bond was actually put to court fines, and it said time served. I was given time served on that case.
Yeah, but. Yeah, it's still open. Well, I mean, that,
Battering anyone?
Yeah, your attorney can try to straighten that out tomorrow when the courts are open. I can't, all I know today is the clerk's computer shows that it's still open, that you are out on bond on it. I revoked that bond, and tomorrow your attorney can check and see whether that's correct information. Obviously, if for some reason it's a mistake and the case has been closed, then they'll release you on that, and then you'll have the $5,000 bond on the new charge. All right, thank you. Kayla Huteling, Hoteling, okay. You're here on a domestic violence battery charge. You originally had no bond on that. Court is going to set a bond of $500 and no hostile or unwanted contact with the victim.
Does that mean that we can still like I can still talk to him?
Yeah, you can still have contact, but if it turns hostile, like screaming, yelling, throwing stuff, that could violate your release, your bond. Or if he decides he didn't want to see you anymore or have you around, you can't say, well, I'm staying, I'm not leaving, because that's a violation of your bond.
Okay.
I'm not making PTR a condition.
Judge, was the PC finding for essentially assault, or is,
I believe it was, yeah, because she allegedly grabbed him.
okay, so it's
So it is a battery.
just a typo in the paperwork. Okay.
All right, thank you.
Thank you.
Roberto Latore, state your name.
Roberto Latorre.
All right, you're here on a domestic violence assault, and state your name, ma'am?
Christina Hall.
And are you the victim in this
Yes.
case? And you wanted to say something to the court about his release or conditions of release?
Yes, yesterday was a big misunderstanding. My husband found his father dead 12 years ago yesterday. He was having a hard day. I didn't feel threatened. I didn't even call the cops. The neighbors called the cops and they lied on their statement. I love my husband. My husband does not beat me. He's a wonderful husband. He's a wonderful father. He was just going through a lot yesterday.
All right, does the state wish to ask any questions?
So he didn't touch you at all?
No,
He didn't strike you? He didn't
No.
throw anything at you?
no,
He didn't threaten you?
no.
Okay,
I didn't want to press charges or nothing.
And he qualifies for pretrial release? All right, I'll authorize his release on pretrial release. The state attorney's office still could choose to file on it, just, but they may not based on your testimony here today. But I am ordering no hostile or unwanted contact. So if something happens where the two of you get into some kind of disturbance again and the neighbors call, that could violate his release. You understand that?
I mean,
Doesn't matter whether he commits a crime or not. If the two of you are yelling, screaming, throwing stuff at each other, whatever.
every couple, every husband and wife,
Well,
they have
it's-
their arguments.
Well, right now,
Yes.
you get into a hostile situation and he could go back to jail with no bond.
Right.
So
It
between
wasn't
now
even
and the case
hostile.
being resolved,
Right.
both of you better be careful if you don't want him to go back to jail, okay? But if it does come a time you don't want him around while
I
this
always
case
want
is
him
still
around.
open, you can tell him that and he has to leave or not be around you until the case has been resolved.
Okay.
Okay?
Thank
All
you,
right.
Your Honor.
Thank you. Jesse Majors. State your name.
Yes, sir.
State your name.
Jesse D. Majors.
All right, you're here on a domestic violence battery case. You originally had no bond on that.
Yes, sir.
The court is going to set a $1,000 bond in order no contact with the victim.
Yep.
Thank you.
No, not on this. You're upset.
Zachary McClendon. State your name. All right, you're here on a domestic violence battery charge. You originally had no bond on that. At this time, the court is going to set a bond of $1,000, order no return to where this occurred, no contact with the victim, and pretrial release is a condition of release.
Sir.
All right? Thank you. Derek Murray, or McMurray.
All right, you're all set. Oh,
Got to go the other way.
you're all good.
State your name.
Derek McMurray.
All right, you're here on a domestic violence battery charge. You originally had no bond on that. Court is going to set a bond of $500. No hostile or unwanted contact with the victim. What that means, if you get into yelling, screaming, if they choose to have contact with you, that could be a violation even if you don't commit a crime. Also, if they don't want to have contact with you, you can't have contact of any type, phone calls, social media, third parties, driving by. You understand all that?
Judge.
Yes.
This is my brother.
Yeah, 1 second. Judge, the alleged victim, I think, is behind me.
Right.
I didn't know if,
Yeah, I know, but there, I'm not prohibiting contact.
I
I'm just saying if I'm no hostile or unwanted contact.
Okay.
And he's gonna get the same conditions. So if you don't wanna have contact with him, he can't do that and it'll be a violation of his release. If he doesn't wanna have contact with you, you can't have contact with him or it'd be a violation of yours. But if you both want to do it and it doesn't turn hostile like it did this, or allegedly did this time, then that's okay. You can post your $500 bond, get out and wait and see if they're gonna file charges.
Okay.
All right? Thank you. And Kevin McMurray? Oh, I thought he was here. Oh, okay. All
I
right.
thought he was behind me.
So this needs to reset for tomorrow. Mental health. Okay. Terrence Pugh? Okay, no, on that, let's go back one. Apparently, the norm during the week is for the public defender to waive their appearance if they can get a bond and conditions. On this one, I'm gonna do the same thing as, with the PD waive the appearance, so I can go ahead and issue.
Yes,
Set a
Judge.
bond? Okay.
Thank you.
So I'm not gonna reset it for tomorrow. I'll just enter a, bond of $500, no hostile or unwanted contact. All right.
That's on the other McClendon?
Yes. All right, Terrence Pugh, state your name.
Terrence Pugh?
All right, you're here on a domestic violence battery charge. You originally had no bond on that. At this time, I'm going to set a $500 bond, no hostile or unwanted contact with the victim. I think you heard me tell the last gentleman that.
What that means?
What
Yeah,
that means? Okay. Thank you.
No problem. Thank you.
No. Yassine Squires, state your name.
Yassine Squires.
All right, you're here on a domestic violence battery charge. You originally had no bond on that. At this time, I'm setting a bond of $500, no hostile or unwanted contact with the victim. All right?
Got it.
Thank you. No.
No hostile.
Christina Taylor. State your name.
Christina Taylor.
All right, you're here on a domestic violence battery charge. You originally had no bond on that. At this time, the court is going to set a bond of $500, no hostile or unwanted contact with the victim. All right? Thank you. No. No. Ashley Urena, state your name.
Ashley Arena.
All right, you're here on a domestic violence battery charge. You originally had no bond on that. At this time, the court is going to set a bond of $500 with no hostile or unwanted contact with the victim. All right, thank you. And no PTR. Janina Vega, state your name.
Janina Vega.
You're here on a domestic violence, violation of a domestic violence injunction. You originally had no bond on that. At this time, the court is going to release you on pretrial release. And if that junction is still in place, then you cannot have contact, or it would be another violation of not only that injunction, but it would violate your release and could cause you to be put in on no bond and stay on no bond. So until that injunction has been lifted, you have to comply with it. All right?
Yes, sir.
Thank you. Yeah. Tammy Witter,
Yes,
state your name.
Amy Witter.
You were incarcerated on a domestic violence battery charge. You originally had no bond on that. At this time, I would allow you to be released on pretrial release with special conditions of no hostile or unwanted contact with the victim.
Okay.
All right? Lethadius Anthony, state your name. All right, you're here on an aggravated assault with a firearm, 2 counts. That originally had no bond. At this time, the court is going to set a bond of $2,000 on each count, so that would be $4,000 total. Cannot possess any firearms, no contact with the victims, and no return to where this occurred. You understand all that?
Yes, sir. Can I say something?
Well, you may want to ask your attorney first. Excuse me? Yes, pretrial release as a condition. Thought he didn't qualify. Yeah, he does qualify, I'm sorry. I meant to.
You're all set.
Yes, and pretrial release is also a condition of that release. Lavania Brown? State, okay, state your name
Savannah
and last name.
Brown.
Okay. You were picked up with possession of cannabis with intent to sell. They originally scheduled a $15,000 bond. They then changed that to no bond because of the schedule. And then you also have carry and concealed firearm, which is a $150 bond. What the court is going to do is I'm going to reinstate a bond of $10,000 on count one with pretrial release as a condition of release.
Say it one more time.
I'm going to re-establish a bond on count one of $10,000. It was originally 15, but I'll make it 10. Actually, it was 15, and then they made it 0. Now it's 10. 150 on the second, and pretrial release is a condition of the bond. All right? Thank you. No. Cesar Cruz. Okay.
All right, thank you. You're good.
State your name.
Yes, sir. Cesar Cruz.
Okay. You're here on a new charge of possession of cocaine, count one, with a $1,000 bond, trespass of the structure of or conveyance, $250 bond, criminal mischief greater than $250 bond, and I'm staying those bonds. You were already out on bond on a child abuse and battery charge, so I am revoking the bond on that case. So it would be no bond until you get a bond hearing in front of a judge assigned to that case.
All right, so, correct, yeah, your bonds revoked. I'll email Cornell and let him know. Okay, yeah.
Leon Dawkins. Mental health. Yeah, we probably need a reset on that. There's some revokings there. Oh, that was Leon Dawkins, right? Jeremiah Delpy, state your name.
Jeremiah Delpe.
All right, you're here on a carry and concealed firearm that has a $2,500 bond on it. You apparently were already out on bond on a theft case, so the court is revoking that bond, and you will need to see a judge before a bond can be set on that.
Judge, may I be heard on that?
Yes.
So that theft case, it appears to me originated back in September. The state still has not filed charges on it. It's Delpe, right? Mr. Delpe has essentially no criminal history outside of these two instances. And I do think that the probable cause as to the carrying and concealed is a little tenuous. Given those circumstances, we'd just be asking the court to exercise its discretion and either take no action or set a bond on this new case. Mr. Delpe is only 19. He has virtually no criminal history outside of these two instances.
Well, he's out on bond on a felony, and according to the arrest affidavit, riding around with people with drugs and firearms. So at this time, I'm going to revoke his bond until he can have a bond hearing in front of a judge. Cordero Dempy.
Your Honor, he's mental health.
All right. You want to waive? I was just going to reduce count 1 to 2,500 and leave the other two the same.
That's fine, Judge.
All right, so on the burglary conveyance, I'm reducing that to 2,500 instead of 3,500. Stay the 100 on the other two, so for a total of 2,700 on bond. Yes. Riley Gamble?
His behavior, Your Honor.
All right, that one needs to be reset. His behavior. Nicholas Henry? State your name.
Nicholas Henry.
All right, you are here on a burglary dwelling with an assault or battery. Originally had no bond on that. At this time, the court is going to set a bond of $2,500. No return to where this occurred and no contact with the victim. Thank you. You want to waive his appearance and stay the bond at 5,000, or do you want to reset it for tomorrow?
I'd rather reset this one, Judge.
All right.
Thank you.
Murphy, the floor.
John Murphy, state your name.
John Murphy.
All right, you were picked up on driving license revoked, habitual offender, and you have a $2,500 bond on that charge. Thank you.
Judge, would the court consider PTR or bond or PTR to see if he can get qualified?
Not at this time. If they want to screen him, I can't remember, did he qualify for PTR? Okay. Well, for right now, I'm just going to stay the bond based on the facts and nature of the charge. San Van Nugen,
Yes, sir.
or is it Nguyen? How do you pronounce it?
It's when.
Okay. You're here on a new charge of fleeing, attempting to elude with sirens, count 1, which originally had no bond, moving traffic violation while driving license suspended, that's a $100 bond, and resisting officer without violence, that's a $100 bond. I'm going to set a bond on count 1 of $5,000. You were already out on bond on a theft case. The court is revoking the bond on that case, and it'll need to remain no bond until you see a judge to get a bond reset on that. Thank you. Michael Orsley, or Orsi? Is it, well, it's, on mine it's O-R-S-I. Is that a typo?
For Ortiz?
Orsi.
210287770.
He bonded? Okay, that's why we don't have him on that document. So Joel Ortiz. He bonded. And how about Marcus Patterson? All right. State your name.
Patterson.
All right, you're here on a battery causing bodily harm, count 1, which is a $100 bond. Count 2 is an aggravated assault with a deadly weapon. that originally had no bond, and count 3 is an obstruction of justice by tampering, and that's a $150 bond. As to count 2, I am going to set a bond of $5,000 with no contact and no return to where this occurred, no contact with the victim.
I don't have it in front of me. Judge, do you happen to have the name of the alleged victim in front of you?
Tiffany Godden,
Yeah, they keep calling it B1 and B2, or B1. But yes, Tiffany Gaudin, Gaudin,
Thank you. And the bond for count 1 was?
5,000.
Thank you.
Jesse Patillo,
Hmm? So you have 3 cases total.
let's see if they want to waive.
Bond.
Yeah, they've already stayed the bond on the other 2 counts. Apparently Jesse Patillo is behavior. Do you want to waive his presence? I was just going to stay the bond of 5,000 and 500. Or do you want him to be brought over tomorrow?
Yes, Judge, we can waive.
Yes, switch.
Oh, we can waive. I apologize.
So I will stay the bond at 5,000 on count 1, 500 on count 2, for a total of 5,500. Kelvin Reese. Darnell Sideline. That one we probably need to reset because he's got a couple of cases he's out on bond for that'll probably be revoked.
Yes, please. Thank you.
Dontavius Smith. State your name.
Dontavius Smith.
You're here on a robbery by sudden snatching. You have $1,000 bond on that charge, but you also were already out on a charge of robbery with sudden snatching, so that is going to be revoked and would be no bond until you see a judge.
Okay. So, attorney in Division 16, no.
McClan Sully. Harrison Whitley. State your name.
Harrison Michael Whitley.
All right, you are incarcerated on a charge of possession of methamphetamine. That has a $1,000 bond. Thank you. Jared Williams. State your name.
Gerard Williams.
All right. You have a count 1, which is a possession of a firearm by a convicted, or weapon or firearm by a convicted felon. You have a $4,000 bond on that count. Possession of ammunition by a convicted felon is count 2. You have a $150 bond on that. I am going to stay those bonds, but also make pretrial release a condition of your release if you bond out. Right? Thank you. No. Well, other than no firearms, but I think that goes without being said. Yes.
You're all set.
Hector Morin Ortiz. State your name.
Luis Moreno Ortiz.
All right. You are here on a charge of damaging our criminal mischief under $200. You do have a $1,000 bond that was set on that. And the court is going to stay that bond. Thank you. 1,000. Jeffrey Gordon. Who do we have here?
210-28772.
All right. Travell Hargrove.
Yes, sir.
State your name.
Javale Lamonte Hargrove.
All right, you're here on a driving license suspended or revoked. You have a $500 bond on that case. You are already out on a bond for resisting officer without violence. The court is going to revoke that bond, and that'll remain no bond until you see a judge. All right, thank you.
I'm sorry, Your Honor, before we move on to the next case, is the resisting charge something that the state would be willing to plea out this morning?
I don't think.
I didn't catch this when,
Well, it was resisting officer without violence. I'm guessing, I'm not comfortable letting him enter a plea because I don't know anything about the facts of that case. Normally, the state wants to talk to the officer. I know it's without violence, but I don't know anything about the case.
It actually hasn't been filed on yet.
Do you know what the facts were? Do you have a? Can you tell what, has it been filed on or not?
It has not been filed on yet, Your Honor.
And how old is it? When would it supposedly happen?
It was on the 19th of November.
Oh, so it's not very old.
The state doesn't have an offer at this time.
Okay, well, it's just gonna have to be revoked until you see a judge. Artradius Bond, state your name. All right, you're here on a failure to appear. Judge that issued that pickup set a $250 bond, so that's what it'll have to remain until you go see that judge.
Yeah, I see what judge.
Well, it was
I'm sorry, for Orlando?
Judge Dubois. So I don't know anything about, it just was a failure to appear at arraignment, and he set a $250 bond. So if you make the bond, you can get out pending going to see him. If you can't, he'll see you hopefully soon.
could, Madam Corrections, let me know if there are any, active holds or extraditions for him. Does that have a bond on it? Yep.
Bo Chin, state your name. All right, you're here on a trespass in a structure or conveyance. You have a $500 bond on that, and a retail theft, which is a $100 bond. Apparently, you were already out on bond on a retail theft, so that is going to be, actually, you were RR'd, but you're out pending that case. And so the court is going to revoke your ROR, and you will have no bond on that case till you see a judge.
What happened?
Sorry, Judge, we didn't hear that last part.
He was already out on a retail theft, so I'm revoking his release on that case. It'll be no bond until he sees a judge. He's got a bond on the new case of 500 and 100 for a total of 600.
Means you're no bond for that. On the retail theft where you were out on bond.
So I gotta see the judge next time.
Yep, you're all set.
Marisol Martinez. Bernard O'Grady. Marcella Cusada. You want to waive and stay the bond at 500?
Your Honor, what's the last name on that?
Cusada, Quezada. Where's the booking number on here? Okay, it's 2102878. Did they? Okay. So what about Tasha Robinson? That one's mental health. Okay.
Judge, could we reset? There's a withhold time served offer.
Okay, I'll reset for tomorrow.
Thank you.
Vanessa Santiago,
She is medical, Your Honor.
you want to waive and stay, or you want to reset? I was going to stay the 500 and 100.
If we can, let's reset. There's also a time served offer for her.
Okay, we'll reset
Thank you.
for tomorrow. Yes. And I have a Jane Doe. Do we have a name for that person? Oh, okay, Jessica Scooby. You want to,
Same with her, Judge, please.
okay, reset for tomorrow, mental health. Trevante White, state your name. All right, you're here on two charges, possession of drug paraphernalia and resisting officer without violence. Each of those have a $500 bond. Was there an offer on this one?
Yes, Judge, PTD or withhold court costs. Yes, he'd like to accept the credit time served offer, Your Honor.
Is that the offer of the state?
Yes,
We have court costs. Was that a withhold or a adjudication?
Withhold, Your Honor. Withholding court costs. Credit for that.
No,
So it's just
220?
220. Yeah, wait, no, this one has a state fee on it, so it is 273. I'm sorry.
Okay,
Oh, he did. I gave him my pen.
all right.
Can I approach?
Yes, we need to swear him in. If you'll raise your right hand, please.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God? Thank you.
All right, just need to ask you a couple of questions before I accept your plea. Need to answer out loud so we can hear your voice. You may need to speak up a little bit because of the mask. Do you understand what's going on here today?
Yes, sir.
And did you go over this plea form with your attorney, and do you understand the information that's in it?
Yes, sir.
And you understand by entering this plea, if I accept it, I'll go forward with sentencing with the agreement, but you are waiving your right to have a jury trial on these charges.
Yes, sir.
And the defense going to stipulate to a factual basis based on the sworn affidavit in the court file.
Yes, Your Honor.
Based on the sworn affidavit in court file, we'll find a factual base for the plea and would accept the plea. And at this time, I move, does he have 2 days?
Yes.
I'll enter a sentence of 2 days in the Orange County Jail with credit for 2 days you've already served. You'll have $273 in court costs, those to be paid within a year. If they're not paid within a year, be reduced to judgment. Any questions? All right. You have 30 days to appeal any issues in reference to the sentencing. Thank you.
Thank you, Judge.
Sherry Wiley? That's what? Oh, behavior?
We can waive, Judge.
Okay, I'll just stay the bonds of 250 on the disorderly intox and the 500 on the resisting without. Ernest Code,
Yes, sir.
state your name.
Ernest Code, sir.
All right.
Judge, if I may, yesterday you gave the state 24 hours.
Correct. To supply additional information, does the state have any additional information?
Yes, Your Honor. Permission to approach?
Yes. Have you supplied that to defense?
I have not, but I'm. Just want to make sure I have it.
For the arrest warrant in the court file on this one? Can you print it out for me? Is this just the arrest, the affidavit for arrest
No, Your
warrant?
Honor, this is, notice of state intent seeking.
We're gonna have to have a hearing to determine whether you get a bond. So, PRR. mean, that very well may be. I'm just saying that this is what they're seeking. Just means if.
Anything else from the state?
Your Honor, the state is requesting a no bond.
Vince?
Judge, 5 seconds ago was the first time I saw that. My recollection is that the rule requires a period of notice and some form of evidentiary hearing. So, I mean, without taking the time to look into the case law to confirm if I'm right on this, I think that he's entitled to a bond up until the point where the state has their evidentiary hearing and the trial judge is convinced that pretrial detention is appropriate.
That would seem to kind of defeat the purpose of if the court decided no bond was appropriate, if they've already bonded out and before the bond hearing.
If that were the case, then I think he would just go into custody at that point.
This is what the court's going to do. I've reviewed the affidavits, I've reviewed the information the court that the state presented. It does appear like there's at least a reasonable request. I'm not granting the request today because I do think that the defendant's entitled to an evidentiary hearing before a final decision is made. But clearly there's sufficient information to stay the no bond until an evidentiary hearing can be made. What I'm going to do is I'm going to reset it again for tomorrow because I want the IA judge to do whatever they normally do on these types of cases as far as setting hearings or evidentiary hearings. What I would warn the state, though, is you better get your people lined up because I'm guessing it'll be a quick hearing. Because he's already been in for a couple of days on no bond. He is entitled to a hearing before he's kept in custody at no bond. But there's no way today I can have that hearing, and there is sufficient information from the state to show that they have at least a reasonable expectation of having a favorable ruling at that hearing. Not saying they will, but they do, based on their information, seem to have a reasonable expectation of a favorable ruling. So I am going to keep him in on no bond at least till tomorrow. I'll let the IA judge at that point, if they feel the case law or the statutory law requires some bond, they will set it tomorrow. If they feel like it's appropriate to stay no bond till the hearing, they'll do that. All right, so they'll see you again tomorrow. Thank you. To determine no bond pending hearing. To determine no bond status pending hearing. Well, no, to determine no bond status pending a hearing, because they're probably not going to have a hearing tomorrow, but the question is, does he stay no bond until they do have a hearing? Nelson Figueroa, state your name.
Nelson Figueroa.
All right, and we were supposed to be here yesterday on a disorderly conduct and possession of drug paraphernalia. We're reset it for today. Has something been worked out on this?
Yes, Judge, and we're ready to go forward with the plea. It's a time-served plea. I believe it's as to count 2 because the state had intended to.
Yeah, I think they announced they were not proceeding on count 1 yesterday. Was that correct? Okay.
I approach.
Yes. And I think he has 3 days in. Okay. And what are the costs for him?
$270.
Okay. Just need to ask you a couple of questions. You need to answer out loud. Do you understand what's going on here today? And did you go over this plea form with your attorney, and do you understand the information that's in here?
Yes, sir.
And you understand that if you enter this plea, and I accept this plea, that you would be waiving your right to a jury trial, and we won't have that trial. I'll just move forward with the sentencing. Do you understand that? And defense counsel going to stipulate to a factual basis based on the sworn affidavit in the court file for purposes of the plea.
Yes, Your Honor.
Based on the sworn affidavit in court file, we'll find a factual base for the plea and would accept the plea. I'm going to dismiss count 1. He's pleading to count 2. Sentence you to 3 days in Orange County Jail with credit for 3 days you've already served. Withhold adjudication, you have $273 in court costs, those to be paid within a year. If they're not paid within a year, they'll be reduced to judgment. Anything else?
Cost in a year.
If you can pay it in a year, you're supposed to. If there's still any outstanding, then it'll be reduced to judgment.
All right.
All right, thank you.
I'm gonna sign that.
You'll be released today as to these charges. Bahaloli, is it Amanda Gooden? Oh, still mental health. You still want it rescheduled for, oh, this is an out-of-state, out-of-county warrant. What are they gonna move her? Well, I'm just gonna order she be brought to court within 24 hours of being cleared. Okay? Shauna Greek? She refused? All right, well, I'm just gonna stay her bond, $1,000 for the cocaine charge and $500 for the drug paraphernalia charge. Yes, I am appointing a public defender. She has an add-on bond.
You don't have the form because it's a reset. Look to the front. It's listed on computer.
All right, well, that's being revoked. And there'll be no bond pending a hearing. Is that a misdemeanor? The 16367? Yeah, that's the one I'm revoking. She has, is there a third case? All right, that's the only one, okay.
Let's make sure. Cheryl, you only have 2 cases, the new case and then the add-on bond case, right? Okay, so he revoked it and he stayed the bond on the.
New cases.
1,500. When
Kelton Little,
Yes, sir.
state your name.
Shelton Little.
All right, you're here on charges of burglary of a conveyance, count 1, that has a $3,500 bond, criminal mischief, count 2, more than 200, less than 1,000. You have a $100 bond on that case. Those are the only 2, right? As far as we know. Why do I only have 1 arrest affidavit? Oh, okay, okay. All right. So on 21-15670, you've got burglary of conveyance, count 1, 3,500, petty theft, count 2, 100, and criminal mischief, count 3, 100. On already announced on 21-15669, which is the burglary conveyance and criminal mischief of 3,500 and 100. have 21-15668. That's a burglary, conveyance, and criminal mischief, 3,500 on the front, count 100 on count 2. And on 21-15667, you have burglary, conveyance, count 1, 3,500, criminal mischief, more than 200, less than 1,000, 100 on count 2. And on 21-15666, you have burglary, conveyance, count 1, 3,500, criminal mischief, more than 200, less than 1,000, 100 on count 2. And on 21-15665, you have burglary, conveyance, count 1, 3,500, grand theft between more than 750, less than 5,000, 150 bond, and criminal mischief, more than 200, less than 1,000, 100 bond on that. All of those bonds are stayed on each of those cases. Do you have any questions?
Any questions?
All right. Thank you. Jaquez Medlock, state your name.
Jaquez Medlock.
You're here on several different cases on 21 MM 8743, which is resisting without violence. You have a $500 bond on that case. On the 21-30128, you have a failure to appear on a felony case. Capias was issued with no bond by the judge who you failed to appear in front of. That's going to remain no bond until you go in front of that judge. Those are the only two.
And Judge, Mr. Medlock was inquiring as to whether the court would be willing to amend that, that no bond order at this time.
I am not. That was issued by the judge he didn't show up in front of, so it'll need to remain no bond until he sees that judge. All right.
That I don't know. You probably do. I just don't have a computer in front of me. I don't think you have it either, but.
Jerry Warren. State your name.
Jerry Warren.
All right, you're here on a new charge of battery with a $500 bond. You apparently are already out on bond on a number of cases. On 21-6222, which is an expired driver's license, you're out on bond on that one. You also have 21-6221, which is a driving license revoked. And you also have a 21-CT-6885, a DUI that you're out on bond on. Each of those, the court is going to revoke the bonds. They'll remain no bond until you see a judge to get a bond scheduled.
So Judge, we were reset this morning because the court did not find PC on the battery charge. And we were reset for the state to provide additional information.
And has the state supplied any new information?
Your Honor, the state has not been able to make contact with the arresting officer to get additional information. The state would ask for an additional reset 24 hours
defense would object to that and ask the court to take no action on the out on bond traffic cases.
So you couldn't access the original report? Let me ask the attorneys, what's the max that he can be held pending the state trying to get him new information?
Your Honor, I believe the state is entitled to up to 2 24-hour resets.
Well, what bothers me is, I mean, I don't know what's in the arrest affidavit, but clearly there's a report somewhere. It's just not bad facts, but obviously the officer should have supplied a copy of what he was arresting him for, which he should have been able to access that police report. Don't know why that's not involved in the packet. Also have, you know, but tell you what, this is what the court's gonna do. I'm not going to, I guess it looks like his bonds were endorsed. Was that correct?
Yes, sir.
Which means he's in on those, the bonds were cashed in.
Yes, sir.
So you'd have to post new bonds on those cases.
Well, only if you revoke them,
Well,
right?
endorsed is circled. So I assume that means the bonding company's already come and got their money. Is that correct or am I incorrect? Does anyone know the answer to that question?
I have no idea.
I thought when they endorsed the bond, they got their money back, which means he doesn't have a bond posted. Is that correct?
I
correct. So he would have to post, even if I didn't, if I didn't revoke the bond, he'd still have to post new bonds.
Right.
Okay.
Which is on the listing for
All right. This is what the court's going to do. I'm not going to revoke the bonds. I'm going to stay the $500 bond on the new charge. I'm going to reset it for IAs tomorrow if he's still in custody. If he wants to contest probable cause and maybe get out on no bond or have the case go away, he can come back, he can stay in jail and come back tomorrow. If he wants to post a bond, it's just like anyone else who posts a bond before IAs. We don't make findings. So I'm not the judge tomorrow might revoke it if they have what they need for the bond, for the battery, and they decide to revoke it. But for right now, so he's not out on bond on those because the bonding companies endorse the bond. So he'd have to post new bonds on those and bond on the 500 new case. But if he does all that, he won't have a hearing tomorrow to determine whether or not the state is able to produce probable cause on the arrest affidavit. So I'm resetting an IA for tomorrow. Obviously, if he's bonded out, they won't have it. And I'm staying all the bond, I'm not revoking the bonds he's already, what he was on, and I'm staying the 500 till the IA tomorrow or until he bonds out on it. Okay? Still not finding PC as to the battery, but I'm resetting it for tomorrow. If he bonds out before then, so be it.
downtown. The recommitment, the reason why, the bondsman came out for the bond. I guess he bonded out the last time before he came to IA.
Right.
So he's never been IA on these. So you want me to stay the bonds and appoint the public defender or reset the whole thing?
No, just stay the bonds and appoint the public defender.
On the recommitment?
Yeah.
Okay. He's taking no action as to the add-on bonds, but as to the recommitment, he's gonna have to repost those bonds. So he's gonna stay those bonds what they originally were, and he's appointing the public defender.
Did take a break to finish reviewing the arrest affidavits, and would announce that for all the Orange counties, I would be temporarily appointing the public defender's office for purposes of their detained status, that I reviewed all the arrest affidavits that I will be announcing and have found probable cause unless I indicate differently. So I need Yadil Valerus.
Sí.
State your name, please.
Yadiel Omar Valle Ruiz.
Do you need an interpreter?
Yes.
All right, we got headphones.
And good morning, Your Honor. Marie Taylor on behalf of the Office of the Public Defender.
Sí.
All right.
Contact, Your Honor.
I didn't know this.
All right, you are here on a case charging you with count 1, burglary of a dwelling with an assault, and count 2, domestic violence assault. And you originally had no bond on those two. And what the court is going to do is set a bond of $5,000 on count 1, $1,000 on count 2. Oh, we do have, all right, I didn't realize that. Do you need an interpreter?
Yes.
Do we have headphones for her?
I mean, I'm fine with English.
Excuse, ma'am?
I'm fine with English.
You're fine in English?
Yes.
Okay, let's put the headphones back on. That'll be quicker. State your name, please.
Laura Mercado.
Okay, and you're the alleged victim in this case?
Yes.
And you wanted to say something to the court?
I just don't want him to have any contact with me or be near my area or my kids.
Okay, now, are your kids his kids or somebody else's?
I have kids. I have 4 kids. 1 with him.
One is his. Okay, so you understand there has to be some mechanism for him to have
Yes.
at least, unless a court orders differently, in a custody issue, he has a right to have some contact with his child. And that would have to be set up through a third party of some sort, because he cannot communicate with you.
Yes.
You understand that? Okay, well, what the court's doing is I'm setting a bond of 5,000 on one count, 1,000 on the other, for a total of 6,000. And I am ordering no contact with you, and no return to where this occurred, other than he can return once with law enforcement to retrieve any personal items he needs to retrieve. Does he have any personal items there?
I think he has something of his work.
Okay.
Yes.
Okay, he can return escorted by law enforcement one time to retrieve whatever personal property he may have. Probably be to your advantage to put it in one location so they don't have to go through the whole place to look for his stuff.
Okay.
And do you have any questions about any of this?
About social media, because he's been humiliating me on public on social media, posting pictures and everything.
Well,
Sorry, I can't hear, Judge.
she's saying he's been contacting her on social media, is that correct?
I mean, humiliating me.
He's what?
Humiliating me and posting pictures and saying
Okay,
about myself.
well, let me make it clear to both of you. When I say no contact is a condition of his bond if he gets out, it means absolutely no contact. No third-party contact, no posting things on social media, no asking people to pass messages, no putting signs up in people's yards. We've had that happen. Just make sure you understand, if you violate any of those, especially on social media, because there's a record of it, they can come in and show the judge that you posted something you weren't supposed to. The judge is going to revoke your bond, and you're probably going to stay in on no bond, since the judge might find that any bond isn't going to keep you from doing what you were doing. So just be careful of that. So it's a total of 6,000 and no contact with the victim while this case is pending and you're on bond. Does anyone have any questions? All right, thank you. Roslyn Oliveira Vega. Need to put headphones on. Let me ask the witness in the booth, can you hear me?
Yes,
And
Your Honor.
do you need an interpreter, or are you okay?
No, I don't.
Okay. And I need, if you'll state your name for the record, please.
Rosalind Oliveras.
All right.
Rosalind Oliveras.
And you're here on a domestic violence battery charge. You originally had no bond. Let me ask, are you the alleged victim?
Yes, sir.
Okay. And you wanted to say something to the court?
First, to my wife, that I love her. I want her back right away in my house. And that's what I need to say.
Okay. State wish to ask any questions?
No, Your Honor.
All right. What the court, you originally had no bond on this case. What the court's going to do is set a bond of $500 and no hostile or unwanted contact with the victim. So it means you can have contact, but if he says, I don't want you around, or I don't want you here, or I don't want to have contact with you, that's a violation of your bond if you don't leave or don't leave him alone. If you get into a fight with him, even if you don't commit a crime, if it's hostile, screaming, yelling, doing things that are hostile, it may not be a new crime, but it would be a violation of your release.
Okay.
And she does, okay. Well, I'm not going to make it a condition on this particular case.
Can I say something?
Yes,
I'm sorry.
that's okay. You want to say something?
Well, yes, it wasn't violence at all.
Well,
it was more like domestic disturbance. That's it.
Okay.
First time she never reacts like that.
Well, I'm
Nothing.
setting the bond as low as I can. I'm not making pretrial release a condition. So she just needs to post the bond and not have any more issues until this case gets resolved. The state attorney's office will decide if they are going to file any charges or want to send you to some kind of diversion program or drop the case. But you can let the state know how you feel about it and what you want, or what you want them to do with the case. They don't automatically have to do it at the victim request, but they usually give the victim a lot of, or try to do what the victim wants if they can. All right? So she'll have a $500 bond. If somebody posts it for her, she can get out.
Okay.
All right, thank you. Are there any other interpreter cases that we know about?
No, Your Honor.
All right, so we can excuse the interpreter.
Your Honor, will any of the witnesses need a Spanish
Oh,
interpreter?
that's a good question. Do we know if any of the witnesses need an interpreter? Okay, apparently they've asked and nobody indicated they needed an interpreter.
Okay, thank you very much, Your Honor.
All right, thank you. Kevin Dinger,
Yes, sir.
state your name, please.
Kevin Lance Dinger.
All right. Apparently you were picked up on a warrant out of Citrus County. There is a $2,000 bond on that, so that if you can post a $2,000 bond, you could get out pending you showing up in Citrus County for a hearing. If you can't make that bond, you would have to stay incarcerated till they can transport you to Citrus County, and my understanding that is supposed to happen within 72 hours. So if you're still here in 3 days, I've temporarily appointed the local public defender's office to represent you on your detained status, so you need to contact the public defender, tell them you're still here, it's been more than 3 days, and they'll check into why you're still here. There may be other cases, there may be other reasons, but for right now, I would assume they'll move you if you don't bond out. All right?
When you say $2,000 bond, how much do I have to post?
Well, it depends on whether you have some property to put up, but that's up to a bondsman. Normally, it's 10%, depending on the property that you put up for collateral. All right? Thank you. And state your name.
Michael Lee Bennett.
Okay. And you're here on a urinating in public charge with a $250 bond. I assume this was a pleable offense if the state was willing to make an offer.
Yes, Your Honor, at this time, the offer would be withhold court costs and credit for time served.
I mean, I guess if nobody appeals, but technically if it's time served, you can't withhold.
I'm sorry.
Because it's a straight sentence.
I think you can on a misdemeanor.
On a misdemeanor, are you sure? I'm not 100% sure about the misdemeanor. I know on felony you can't, but I thought even on a misdemeanor, if you don't put them on probation, you have to adjudicate.
Misdemeanor, the withhold is good. It's just the statute on the felony. Statute on the felony.
And let me, what's the court cost? Actually, okay, I'm not gonna technically appoint the public defender. 223.
Questions about this?
All right, we need to swear him in. If you'll raise your right hand as best you can.
Do you solemnly swear and affirm the testimony you're about to give should be the truth, the whole truth, so help you God?
I do.
Thank you.
All right, just need to ask a couple of questions under oath. You need to answer out loud so we can hear your voice. Do you understand what's going on here today?
Yes, I do, Your Honor.
And did you go over this plea form with your attorney, and do you understand the information that's in it?
Yes, I did.
And you understand that if you enter this plea today and I accept it, I will go forward with sentencing based on what the agreement was, which was time served and court costs. And you normally would be entitled to a jury trial, but you'll be giving up your right to that trial in order to enter this plea today. Do you understand that?
Yes, I do, Your Honor.
All right, and defense going to stipulate factual basis based on the sworn affidavit and court file for purposes of the plea.
Yes, Your Honor.
based on sworn affidavit in court file, will find a factual base for the plea and would accept the plea. I assume he's got 2 days credit.
Yes,
Okay. So I will sentence you to 2 days Orange County Jail with credit for 2 days you've already served. You'll have $223 in court costs. Order that to be paid within a year. If it's not paid within the year, it would be reduced to a judgment. And they would release you today as to these charges. If you've got some other hole, then I can't fix that. But if this is all you have, they'll release you today, and you have 30 days to appeal any sentencing issues. All right?
Yes, Your Honor.
Thank you. Yes. Oh, no, he's withhold. And that's it for the move-ups. So I'm going to go through the rest of the Orange